So in this video, I have an update for you on the Texas Suppressor Freedom case, which aims to stop the NFA and ATF's regulation of suppressors. The 5th Circuit Court of Appeals will now hear this case next week, and the panel we got to hear this case is a slam dunk for the Pro 2A side. So let's talk about what just happened. Now, before we jump into this video, I want to make 2 channel announcements. The first one's going to be that I'm actually going to be attending GunCon. It's a convention that you guys, the viewers, can come to. It's going to be in Iowa. It's going to be at the Brown House facility. You have to get tickets to attend. I'm going to be there. A bunch of other gun content creators are going to be there. A bunch of companies are going to be there. I'm going to be on a panel talking about the Second Amendment with friends like Jared from Guns and Gadgets and a lot of other guys. And there's going to be a bunch of other content creator panels. So again, if you're interested, you guys, the viewers, can come, hang out with us, talk with us, attend those panels, go to a range day, meet a bunch of vendors. So it's something that is open to the public, but you have to get tickets, and you can find those using the links down below. Also, I want to make you all aware once again that we do have a podcast available. It's a podcast I'm doing with, me, my friend Jared from Guns and Gadgets, and then also Johnny B. It's called the Liberty Lounge. Again, I will leave a link to that down below. We would love your guys' support. The feedback has been amazing. You guys are really supporting that. It's available on YouTube and then also on all audio platforms. But again, links will be down below. As I mentioned in the intro, in this video, we're going to be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATF's regulation of suppressors. The ATF is now trying to get this case thrown out of the 5th Circuit by arguing that any positive decision will cause an improper circumvention of people like me and you paying a required NFA tax. The case we're going to be talking about is Paxton versus Dettelbach. Last July, the federal district court judge issued an order in favor of the ATF granting their motion for summary judgment, and he dismissed the entire case because he believed the plaintiffs lacked standing to bring the lawsuit. Texas appealed that ruling up to the 5th Circuit Court of Appeals, and all of this is coming to a head when there's going to be oral arguments next week on May 1st. So next week, the 5th Circuit is going to hear this case. Now, we recently received news that the 3-judge panel that will hear this case has been selected and released. The panel is 3 conservative appointees, 2 of which were on the Rahimi case. Now, if you're not aware, Rahimi was a big Pro 2A win after the Bruin decision. Corey Wilson wrote the majority opinion in that Rahimi case, and he was joined by Edith Jones. As you may recall, that Rahimi decision used what the Supreme Court said in Bruin, which was the text, history, and tradition standard, and they used that to strike down the federal domestic violence restrictions that were in place. That decision is now currently waiting also for Supreme Court review. But the fact that we got 2 of those judges on this panel bodes well for this suppressor case and the hearing that is happening next week. Now, the ATF recently submitted their brief arguing that the 5th Circuit should uphold the dismissal of the case, and also they even argued that the case should not be heard, but like I said, the 5th Circuit rejected that. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this law is that since these items are made and sold in the state, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. After Texas passed that law, the ATF sent out warning letters threatening that they would in fact enforce the NFA GCA's regulations against made in Texas suppressors. So again, it's very concerning for you guys in Texas. Make sure you wait for this case to play out. Wait for this Paxton case to be decided by the 5th Circuit and the district courts, because again, you don't want to engage in this conduct because the ATF will enforce the NFA and GCA's regulations against made in Texas suppressors, despite what the state's law says. Now, in response to that, Texas, along with individual plaintiffs, filed a lawsuit against the federal government. The case was then submitted to a federal district court on cross motions for summary judgment. Well, after reviewing the case, the district court granted the motion in favor of the ATF. On review, the judge found that the plaintiffs have not suffered an injury in fact, and therefore they do not have standing to bring this lawsuit. Here, the judge essentially stated that the individual plaintiffs would have to allege that they possess an illegal silencer or that they have engaged in some other prohibited conduct that the ATF claims is illegal. The judge also stated in the opinion that alleging the law is unconstitutional and impacts the Second Amendment is invalid and does not actually help them get over the burden of showing standing. They also said that they could not use Bruin and that recent decision by the Supreme Court to, bolster their Second Amendment arguments to also show that there was irreparable harm when it comes to, or, an injury in fact in regards to violating their constitutional rights. Now, in response, Texas asked the 5th Circuit Court of Appeals to reverse that lower court decision. They filed an appeal up to the Fifth Circuit. The ATF responded to that appeal and argued that the Fifth Circuit should essentially affirm what the lower court said in their dismissal, and in fact, the Fifth Circuit should not even hold oral arguments in this case. Now, that was rejected, the whole concept of not even hearing this case, that was rejected by the Fifth Circuit, but the ATF mainly is arguing right now that under the Tax Anti-Injunction Act, or the AIA, this lawsuit was improper since it would result in the avoidance of paying a required tax under the NFA. The ATF claims that the AIA prevents this type of lawsuit proceeding forward, that the AIA has a specific process that the plaintiffs here would have to go through, to file these types of claims, but filing this specific lawsuit would be improper. They would have to go through the AIA's process, mainly being that they would have to pay the tax, then contest the tax with the Attorney General. If the Attorney General denied them contesting paying that tax, well, then they could file a lawsuit, under administrative law against the Attorney General for the recoupment of that tax, but they couldn't file this lawsuit to stop the entire NFA process. Then the ATF argued that the Second Amendment is not implicated at all when it comes to suppressors. They state that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections, and a silencer is a firearm accessory, not a weapon in itself. So what they're saying is that suppressors and these items are not protected under the Second Amendment at all. Now, of course, Texas responds to those and they obliterate those arguments and they point out that this whole tax issue is not even at issue on appeal, that the Fifth Circuit doesn't even have to consider the whole Tax Anti-Injunction Act. What Texas is pointing out here is that this appeal is just about standing, and it's just about whether or not there was a proper dismissal based on standing, including, the aspect of whether or not the Second Amendment is implicated and whether that overcame the whole standing requirements. The lower court's dismissal of this case was because they believed the plaintiffs in Texas lacked standing to bring this lawsuit. The main basis for that dismissal was the court said neither the plaintiffs nor Texas had an injury in fact to meet the standing requirement. The court did not consider the AIA, so the ATF now throwing in this whole tax argument is not, correct, and it's a huge mistake by the ATF leaning exclusively on that argument. Now, very interesting, which will also be developed in front of the Fifth Circuit and during these arguments, is the fact that Texas points out because of the Supreme Court's 6-3 decision in Bruin, which struck down New York's concealed carry processing scheme, Texas and the plaintiffs here have standing to challenge the NFA process. They argue that post-Bruin, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although the ATF cites these opinions as controlling authority from this court, it saves this argument for last, surely because it recognizes the shaky status of these opinions post-Bruin. Here, what Texas is doing is they're using the Bruin decision in a post-Bruin world to say that Bruin said you can challenge these types of processes and you need to look at the text, history, and tradition of the Second Amendment to find if these types of restrictions by the government are in fact proper. Here, also, the Bruin decision should be used and should open the door to challenge this NFA process. And the lower court saying that we cannot do this and that we don't have standing to do this is improper. And all of this is now coming to a head, and oral arguments will now happen in this case next week on May 1st. The three judges that will hear this case and decide this case are Edith H. Jones, who is a Reagan appointee, Edith Brown Clement, who is a Bush appointee, and then Corey Wilson, and he is a Trump appointee. So that's probably one of the best judge selections that we could have ever got for the Pro 2A side. I cannot emphasize enough how good of a panel this is, and probably one of the best draws you can get for a panel in the Fifth Circuit. Now, in fact, Corey Wilson was the judge who wrote the majority opinion in the U.S. v. Rahimi case. Now, if you're not familiar, the U.S. v. Rahimi case is an important case decided in the Fifth Circuit by three judges in regards to applying Bruin and the text, history, and tradition analysis against the federal restrictions on domestic violence restraining orders and the possession of firearms. That was a big decision which is now currently in front of the Supreme Court. It was heard by the Supreme Court and is set to be decided. It was a kind of landmark case coming out of the Fifth Circuit when the first times Bruin was applied to these types of federal restrictions, striking down the federal restrictions, and that came from Corey Wilson and then also Edith Jones. So two of those judges that were on the Rahimi case are now going to hear the suppressor case, and we'll get to decide whether or not Bruin applies to the whole ability of individuals to challenge the NFA's process when it comes to registering suppressors. So those who have been following this Texas Suppressor case, you should be pretty excited about the makeup of this panel. Of course, we're going to have to wait for the arguments to develop next week, and we're going to listen to those and see what happens and see some of the questions that are asked. But as far as asking for the right judges on the panel, you couldn't have asked for any better judges. Now, of course, if we get any more information, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways of that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, but never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.